when these men strutted and smiled and postured before the cameras under the swastika flag.
The Boer War was a great tragedy that affected not only the Boers, but even the black people.
A prolonged and violent resistance to British rule by the Kenya Land and Freedom Army was met in turn with extreme methods to subdue, including torture, mass imprisonment, and mutilation.
The discovery of almost 1,000 unmarked graves of Indigenous children at boarding schools in Canada is forcing the continent to take a look at its genocidal past against the Indigenous community.
These people are systematically oppressed by their own government.
We've been waking up to horrific stories every day, heartbreaking images separating mothers from their children.
So the latest tension started with fears, concern that Israeli police might uphold an Israeli court order and forcibly evict Palestinians from Sheikh Jarrah.
Well, good evening, everybody from London. You're all very welcome. And today is not only the day of the lecture, but it is the day that the Master of Jesus College, Cambridge, gave back to the Benin people their cockerel. And if you want to read about it, it's on BBC News. My name is Douglas Blawston, and I'm chairman of the Cambridge University Land Society Whitehall Lectures. And I'd like to warmly welcome all of you on behalf of Colm Lauder, the chairman of the Whitehall Group, and Ian Marcus, the president of the Land Society, and myself, to this, the 10th Whitehall Lecture, hosted here in London at the head office of Carter Jonas, and broadcast live around the world. I'm very grateful to all our sponsors for supporting the lecture and panel discussion, which will follow. The large international representation at this live lecture broadcast, approaching 250 people in some 20 countries, 30 cities around the world, including from some 37 universities, and a brave number of brave writers and activists who have risked their lives, and some indeed who have been in prison for defending human rights, attests to the importance of Professor Sand's Whitehall lecture tonight, and the undoubted impact of his acclaimed writings and court advocacy. The Cambridge University Land Society is the alumni society of the Department of Land Economy, having over 1,000 members, and is the oldest and largest departmental alumni society in the university, holding as many as 30 events a year. The Department of Land Economy sits in the School of Humanities in the University of Cambridge. It is the pioneer in a holistic approach to the study and research into land use. And so it is entirely appropriate for the Society to present this lecture, as in this holistic approach to land use and ownership, a great part of the fabric must be the rights of people, their human rights. As mankind has evolved over millennia, the rights of indigenous people to the lands they inhabit have needed by necessity to be protected by land borders in all their forms, acknowledged by international law, treaties, and accepted by ethnic and settled traditions. And yet, such borders and who governs those lands have been the subject of incessant wars and invasions by countries, tribes, empires, and colonial forces. In their wake, creating mass incarcerations, enormous refugee migrations, over 28 million at the end of World War II, by way of example. Today's migration flows across so many borders challenge our democratic and moral codes, national and international laws. Many are the claims of colonial powers that they act or have acted on behalf of humanity, but the hypocrisy and many such statements are also evident in so many abuses of human rights throughout history. Professor Colin Sampson, who's on the panel today, has written, over the centuries, national pride and moral authority have been derived from the equation of Western civilization with liberal virtues such as human rights. And yet, ladies and gentlemen, we see just during the lifetimes of many of us, countless cases of human rights abuse, crimes against humanity, in China against the Uyghurs, by Saudi Arabia with the horrific beheading and dismemberment of Jamal Khashoggi, all over much of the Middle East, imprisonment without trial and torture by the USA in Guantanamo Bay, the Windrush scandal here in the UK, massacres in the Balkans, Syria, the Yemen, and West Africa, and so on. In the 1960s and 1970s, when I was a teenager, I personally witnessed and experienced the systematic degradation of the black peoples of South Africa through the white apartheid regime, the legacy of colonial settlers from Europe and the British Empire. I was a witness, as are some of those watching this broadcast this evening, to the results of massive abuses of human rights as people's homes were demolished and they were removed so that they were out of sight of white people and their lands were expropriated, where black people were beaten and effectively restricted to near pure carbohydrate diet, the apartheid of food, to subjugate them further, where black people's rights in law were abused by the legal system and thousands died at the barrel of the state's guns or fell from heights to their death, pushed by agents of the state, crimes indeed against humanity, one consequence of colonialism and empire building. Last November, in Courtroom 600 at Nuremberg's Palace of Justice, where the infamous trials of senior Nazi officials opened in November 1945, and where the first prosecutions against crimes against humanity took place, the 75th anniversary of the trials was commemorated in a ceremony. I was already thinking of inviting Professor Sands to give the next Whitehall lecture, and had written to two friends, Professor Horatia Muirwatt and her husband, Judge André Potocki, in Paris, to ask for a contact. The reply and the starting point for this lecture this evening in London was an email trail titled On the Train from Nuremberg, from Judge Potocki. A former colleague of his on the ECHR was traveling with Professor Sands from the 75th commemoration. As most of you will know, Professor Sands has written an extraordinarily powerful and shattering book, The East-West Street, about the Holocaust in Poland and the Nuremberg trials. In the book, he writes about the Potocki Palace, a former home of the Potocki family, that was usurped and pillaged by SS General Otto Wachter, the Nazi governor of Krakow and Galicia district, and a primary perpetrator of the Holocaust, all as described by Philippe Sands. And so through this email, following a commemoration of the first prosecutions under the crimes against humanity, was my first contact with Professor Sands. On the 70th anniversary of the Universal Declaration of Human Rights, a UK foreign minister declared, "Britain is a global defender of human rights, fundamental freedoms, and democratic values." Some months later, the International Court of Justice ruled that the UK had violated the human rights of 2,000 residents of the Chagos Islands, forcibly deporting them from their homeland. So I now invite Professor Philippe Sands, Queen's Counsel, Professor of Laws and Director of the Centre of International Courts and Tribunals at University College London, noted author and advocate, to give the 10th Whitehall Lecture. Thank you.
Thank you very much, Douglas. It is indeed an honour to deliver this Whitehall lecture. It's lovely to be here in person, actually, after these difficult months. And I would like to begin by expressing my thanks to the Cambridge University Land Society and the Whitehall Group, to its officers and staff, and to Douglas. The invitation, I think, was rightly, I believe, was prompted by my work on crimes against humanity and genocide, cases, academic writings, and books, East-West Street and the Rat Line, exploring the origins of these two international crimes. At Nuremberg, a revolutionary moment. It was the first time that a country's leaders had been held to account before an international tribunal, the creation of new international norms and crimes to protect individuals and groups, recognition that no country and no individual is above international law, and a new approach to international relations, a multilateral and rules-based approach. And matters of injustice and justice are at the heart of both books, and a third one is on its way with a Chilean flavour, personal and political issues, and also the role that individuals can play. This evening, I want to talk about a different story, which isn't entirely unrelated. It too concerns matters of responsibility and silence, issues of memory and identity, but far closer to home, here in London. For we in Britain, who seem to like being distracted by the horrors perpetrated by others, aren't so good at engaging with our own horrors, and in particular with colonialism and enslavement, and the continuing shadow of race and racial discrimination. This lecture is about a place called Chagos. It's an archipelago scattered across a vast swathe of the Indian Ocean. I'm not neutral or independent on this subject, let me be clear at the outset. For more than a decade, I've acted as counsel for Mauritius on a place which this government in this country calls the British Indian Ocean Territory. The website, which you can see here, HMG's official website, describes an archipelago of 58 islands, over 640,000 square kilometres of ocean, a British overseas territory, administered from London, located approximately halfway between East Africa and Indonesia. Access is restricted, the site informs us, although if you look carefully, it does say how to apply for a mooring permit, because owners of yachts are allowed to go there. The website has nothing to say about Chagos's past, or that it is Britain's last colony in Africa, or that Britain is now an illegal occupier of Chagos, just as South Africa was for many years of Namibia, or that the Chagos's entire population was, within living memory, forcibly deported, and that many of the former inhabitants wish to return to their lands. Indeed, Britain hangs on to Chagos. It issues colourful, beautiful stamps, like this one, released just a few weeks ago, the Royal Angelfish, adorned with a portrait of Her Majesty the Queen. The British Indian Ocean Territory Post Office and Stanley Gibbons will not tell you that these stamps cannot actually be used, but more about that later. I'd like to begin with a first-hand account. This is a video that was first shown in September 2018 in the Great Hall of Justice in The Hague. It's a witness statement that was prepared for the 14 judges of the International Court of Justice.
Je m'appelle Lisby Élysée. Bon né le 24 juillet 1953 dans Pérouse-Banus. Mon papa né dans ces îles. Mon maman né dans Pérouse-Banus. Mon grande famille aussi est née là-bas. Je fais partie de la délégation mauricienne. Je peux raconter toutes mes souffrances depuis que je me déraciné aux îles Paradis. Je suis content que la Cour internationale peut accueillir nous aujourd'hui. Et nous sommes confiants que nous pourrons retourner dans nos îles, que tout le monde prend naissance. Dans Chagos, tout le monde est dans ce travail, est dans sa famille, est dans sa culture. Mais nous tu manges tout ce qui est frais. Bateau qui tu sorti depuis Maurice, tu amènes tout nos bonnes marchandises. Nous tu gagnes nos rations, nous tu gagnes tout ce qui nous nécessaire. Nous pas tu manques rien. Dans Chagos, tout le monde qui vive une bonne la vie. Mais un jour, l'administrateur qui finit dire nous, qui nous pour bien quitter nos îles, quitte tout nous la case, nous aller. Tout le monde pas peu content, je suis en colère, qui fait Indien nous bien aller. Mais nous pas à soi, pas nous laisse nous connaître qui fait. Jusqu'à aujourd'hui, nous pas connaissons qui fait nous peut bien aller. Mais après, bateau qui tu peux amener manger, fin arrête venir. Non, rien nous pas pour manger. Aucune médecine, aucune rien. Nous passons bien misère. Mais après, un bateau qui vient, appelle notre verre. L'administrateur qui nous dit nous, qui nous besoin embarquer, qui tous nos bagages, qui tout ça qui nous est là, pour 10 nous laisse nous aller. Et ça, ben, du monde, tu viens en colère qui fait ça. Et quand fait ça dans le noir. Nous embarquer dans le noir pour nous pas trouver nos îles. Et quand nous finissons embarquer dans ce bateau là, avec mauvaises conditions. Nous avons un ban d'animaux, un ban esclaves de ce bateau-là. Ban du monde qui type mort à la sagrin de ce bateau-là. Et moi, à l'époque-là, je suis enceinte 4 mois. Le bateau-là prend 4 jours pour y arriver Maurice. Mais quand il est arrivé, moi, mes enfants finissent et ils finissent morts. Je dis à qui fait mes enfants finissent morts parce qu'ils m'ont traumatisé de ce bateau-là. Moi, il y a beaucoup de tracas, m'ont bouleversé. À cause de ça, même qui quand mes enfants finissent, ils morts. Moi, je dis, nous ne devons pas perdre l'espoir. Nous devons imaginer qu'un jour, nous pourrons tourner dans la terre que nous nés. Moléké a peu souffert et Moléké a encore attaché avec nos îles que nous nés. Mais personne qui n'est pas content, qui est dans cette île que nous nés, pour déraciner comme un ban d'animaux. Et ça fait aller qui a fait mal. Et moi, je dis, la justice bizarre faire. Et mon bizarre retourne dans mes îles. Que de mener. Est-ce qu'il y a quoi? Pas faire les qui a fait mal. Quand on dit qu'on déracine les îles, comme un animal, pas peut connaître que de permet nous. Et moi, bien ça grand jusqu'à aujourd'hui. Moi, pas connaître même comment on sorti dans mon Chagos. Il fait à nous sortir par force. Et moi, bien ça grand. Et moi, là, me coller tous les jours, mon mazine, qui m'a bizarre retourne dans mon île. Moi, dis à mon bizarre retourne dans mon île que de mener. Et mon bizarre almo là-bas. Et que nos grands-parents finissent enterrés dans l'endroit que nous prenons naissance et dans nos îles natales.
So I came to know Lisby Elysée several years ago, and we've stayed in touch ever since. When she first told me her story, it resonated deeply. It reminded me of other acts of deportation, of my 2 great-grandmothers transported from Vienna in July 1942. And like them, Lisby Elysée was allowed to take a single suitcase. When we were at the International Court of Justice 3 years ago, she asked a question. Why, Philippe, has it taken so long to get to The Hague? Justice is a long game, was the best I could come up with. The roots of Lisby Elysée's journey started well before her birth. On Saturday, August the 9th, 1941, the United States ship Augusta was moored in Little Placentia Sound off the coast of Newfoundland, a British colony. On board, Franklin Delano Roosevelt and Winston Churchill quarreled about colonialism and the future of the British Empire. The President told the Prime Minister that they had to work together to end a backward colonial policy. FDR favoured an idea that would become the principle of self-determination. They signed a document called the Atlantic Charter. Churchill called it, and I quote, a British production cast in my own words, end of quote, one that set out his hopes for a better future for the world. What Churchill didn't realise was that he had walked into a trap, Roosevelt's trap. For paragraph 3 of the Atlantic Charter committed the two countries to respect the right of all peoples to choose the form of government under which they will live. For Roosevelt, the Charter was simple. It would bring an end to the British Empire. It would offer the colonized the promise of statehood and independence. But Churchill read the document very differently. He told the House of Commons that the third paragraph was for others. It was only for those, as he put it, under the Nazi yoke. It wasn't for British colonies. But that reading was not widely shared, particularly in Africa. A very young Nelson Mandela read the Charter's words as heralding what he called new rights for blacks, full citizenship, and a total end to discriminatory legislation. One thing led to another. The Atlantic Charter's ideas were picked up by many others, countries as well as people, and influenced the drafting of the United Nations Charter in the summer of 1945. Decolonization was the hottest subject in the hardest working conference I've ever attended, Ralph Bunche wrote of the negotiations in a letter to his wife. He was the lead American drafter of that section of the Charter. And Bunche and the Americans largely succeeded. Decolonization became an aim of the UN Charter. Article 1 committed all members to respect the principle of self-determination of peoples. That was revolutionary language, although it didn't define what self-determination was or resolve the question of its legal consequences. It was compromise, a nod to the British and the French who were fearful about their colonies. And so began the process of decolonization. For Britain, Transjordan was the first to go, then India, with a great deal of bloodshed. The mandate in Palestine was terminated, then Burma and Ceylon gained independence. Newfoundland joined Canada, Libya passed from British and French control to statehood of its own, Eritrea merged with Ethiopia, and so on, and so on. But large parts of Africa remained under colonial rule. France, Spain, Portugal, Belgium, and Britain too clung on to their distant possessions and subjects. In Mauritius, the British governor, Sir Hilary Rudolph Robert Blood, was happily ensconced in what he called my pocket handkerchief paradise. In 1960, in Cape Town, Harold Macmillan evoked a wind of change blowing through Africa. That year alone, 16 African countries joined the United Nations. A British diplomat complained, decolonization is largely based on emotion, not reason, he wrote to London. It's a form of, as he put it, and I quote, colour prejudice in reverse, end of quote. The whole approach reflected, he mused in his report to Home Office, an unjustified resentment of the darker peoples against the past domination of the world by European nations. As he wrote those words, self-determination reached the floor of the UN General Assembly. It was now autumn 1960, 5 years after 29 countries attending the Afro-Asian Conference in Bandung, Indonesia, created the non-aligned movement and declared colonialism to be an evil, to be ended speedily and replaced by self-determination. Resolutions circulated in New York under the direction of Frederick Boland, an Irish diplomat who knew all about British colonialism and who happened to be the president of the General Assembly during its deliberations. Decades later, his daughter, the wonderful poet Evan Boland, would write a most famous poem, which begins with the line, "What is a colony?" On the afternoon of 14th of December 1960, 89 countries voted in favour of the resolution 1514, and none voted against. 9 countries abstained, one of them was Britain. Resolution 1514 declared, as you can see, that all peoples have the right to self-determination. And it proclaimed a principle, in paragraph 6, of territorial integrity, prohibiting the partial or total disruption of the territorial integrity of a colonized country. Britain explained its abstention. It was sort of in favour of a principle of self-determination, but it couldn't accept its characterisation as a legal right. But Mr. Boland from Dublin was thrilled, and he ended the session on an upbeat note. The Assembly may well congratulate itself on this accomplishment. The right to self-determination came into being at the very moment that the people of Mauritius were urging Britain to give them their independence. And at the same time, the United States was developing a new policy of placing military bases on distant atolls. A word about Mauritius. It became a British colony by the Treaty of Paris, signed in May 1814, which ended the Napoleonic Wars, prohibited the international trade in enslaved people, and ceded various colonies to Britain. One of these was Île-de-France, known to the British as Mauritius. It came with dependencies, including the Chagos archipelago, about 2,000 kilometers away, actually closer to the Maldives, which was a British colony. Chagos comprised some 58 islands. They included Diega Garcia, and hundreds of miles to the north, Peros Banhos, named after Pero dos Banhos, a Portuguese explorer who perished there in 1555 when his ship, the Conceição, ran aground. The mariner Manuel Rangel recorded the event and the travails of the 165 people on that boat, who included 2 women and 5 Catholic priests. Stranded on a flat, sandy island, populated with coconut trees, grasses, turtles, and thousands of birds, plenty of drinking water nestled in shallow wells carved into the sand. The shipwrecked were, to put it mildly, extremely surprised to be greeted by a number of locals, as Rangel put it, a group of black people with boats. The 1814 treaty ceded Peros Banhos and the rest of Chagos to Britain, with its copra and oil-producing plantations, worked by enslaved people brought in by the British from Madagascar and Mozambique. By the early 1960s, as self-determination was being written into international law, Chagos had about 2,000 inhabitants, most of whom worked for the Société Huilière de Diego et Peros, descendants of the original enslaved inhabitants. Britain resisted independence, and secretly, very secretly, it acceded to an American request to make one of the islands, Diega Garcia, available on a long lease as a communications facility. The Americans asked the British to empty Chagos, to remove all the inhabitants, and the British agreed, and to do so at HMG's expense. We can do this, a memorandum concluded, but we must avoid the charge that we are trafficking in colonial territory or disregarding the interests of the inhabitants, or worse still, creating a new colony. Ever inventive, Whitehall civil servants and lawyers sought to circumvent international law and Resolution 1514. We can do this either by securing the consent of the Mauritians or simply presenting them with a fait accompli. The Americans asked the British to detach all of Chagos from Mauritius, although they would only use and want Diego Garcia. London agreed. Having declined to engage in the Vietnam War, Harold Wilson felt he needed to give them something, so he gave them Diego Garcia. It must be done as rapidly as possible, Wilson concluded, and in utmost secrecy to avoid scrutiny. The Mauritians objected to detachment. Invited to London to discuss independence, on the 23rd of September 1965, Wilson met the Mauritian leader, Mr. Ramgoolam, at number 10 Downing Street. A briefing paper told Wilson how he must deal with Mr. Ramgoolam. The object is to frighten him with hope. Hope that he might get independence, fright lest he might not unless he is sensible about the detachment of the Chagos archipelago. You can return home with independence or without it, Wilson told Ramgoolam. Diego Garcia can be attached by order in council or with your agreement. Ramgoolam objected and proposed a lease. Wilson refused. And so an understanding was reached on detachment. Mauritius would get independence with a little compensation and a few trade concessions and fishing and other rights around Chagos. The British would get Chagos and undertook that if the need for the facilities disappeared, the islands would have to be returned to Mauritius. Under pressure and reluctantly, a majority of the Mauritian ministers in London agreed to the detachment under these pressurized conditions. On September the 24th, 1965, Britain announced independence for Mauritius. Behind the scenes, Colonial Secretary Anthony Greenwood prepared the way forward. Present the UN with a fait accompli, he wrote, bypass Parliament, adopt an order in Council, detach Chagos, create a separate colony, and do it now. But there remained one significant problem, a human problem. What are we going to do with the inhabitants? The British and Americans agreed to concert tactics and proceeded on the base of a lie. They would tell the UN that the Chagos had, and I quote, virtually no permanent inhabitants. Not good enough, said Lord Caradon, Britain's UN ambassador in New York. He wasn't happy with the word virtually, as any population would cause Britain to be accused of violating its charter obligations to the permanent inhabitants. And so the word was removed. Britain told the UN that Chagos had no permanent population, that the Chagosians were merely contract labourers. The object of the exercise is to get some rocks which will remain ours, a Foreign Office official noted. So Chagos becomes a place, as he put it, with no indigenous population except seagulls. The fiction opened up Britain's fertile colonial imagination. The official wrote, along with the birds go some few Tarzans or men Fridays whose origins are obscure. The Privy Council in London duly made an order in council creating the new British Indian Ocean Territory, all the islands of Chagos. It changed the Mauritius constitution by removing Chagos from the definition of the territory, and it gave to a new Biot commissioner the overwhelming power to remove all the population from the islands. News reached New York, and it prompted an instant reaction. The General Assembly expressed deep concern about the purported detachment and instructed Britain not to violate Mauritius's territorial integrity. Britain simply ignored the resolution, a harbinger of future difficulties. It ignored a second resolution the following year, and then a third a year after that, decisions that declared explicitly the disruption of the territorial integrity of Mauritius would be a violation of Resolution 15 and international law. Instead, what Britain did was enter into a secret agreement with the Americans, declaring Biot to be British and available for the defence needs of both countries, which would last until 2016 and could be extended for another 20 years until 2036. No charge to the Americans, it was a most British gift. In March 1968, Mauritius became independent without Chagos, and a month later it joined the United Nations. The Americans moved into Diega Garcia pretty much immediately. The entire population had been removed. The comedian Bob Hope visited that Christmas, and he was accompanied by a troupe of 75 performers, including 32 American beauties and an Australian recently crowned as Miss World.
We started out early Christmas morning to pay a visit to 1,200 sea bees stuck in the middle of the Indian Ocean on a fly speck called Diega Garcia. This 2,200-mile detour was a command performance, our answer to a lot of requests of the sea bees and their relatives. Finding it was only a minor triumph. We were the first jet to attempt to land there. The sea bees had worked feverishly the last 2 weeks to make this possible. Then we were greeted by a torrential tropical wind and rain. These sea bees were determined to have a show. They waded through the downpour. Nobody budged. Finally, after an hour or so, it cleared enough. And, well, I better get out there and get to work before they mildew over. Where are we? Diega Garcia, huh? That's a little embarrassing because we started out for Honolulu. But we're awfully glad they slid the island under us when we dropped in, I want to tell you that. I'd like to thank you for inviting us here and the flies for giving us permission to land. Our sea bees here share this base with the English. They coexist beautifully in spite of the language barrier.
Well, as you can see, the deportations had already fully taken place. They started in Diega Garcia. Between 1968 and 1973, the entire population of Chagos was removed. Madame Élysée was on the last shipment out in April 73. 2,000 human beings deported to Mauritius, the Seychelles, and Crawley near Gatwick Airport. In the years following independence, Mauritius had many other concerns as it made its way in the world. Then in 1982, at the United Nations annual meeting in the autumn, the Prime Minister of Mauritius called for the return of Chagos. This was a first, and said it had been illegally detached. The Chagosians too began to agitate, including litigation before the English courts, with some success. In 1998, Olivier Bancoult, Madame Élysée's nephew, won a ruling from the Court of Appeal here in London declaring the deportations to be illegal. Foreign Secretary Robin Cook agreed to the return of the Chagosians to the outer islands. And then came 9/11. The US base at Diega Garcia was used as part of the Bush administration's program of extraordinary rendition and the embrace of torture, and in March 2003, with British support, it was used to launch the war on Iraq. A year later, the British government reversed its decision to allow Madame Élysée and the other Chagosians to return to Paris-Bagnas and other outer islands. Robin Cook was gone, Jack Straw was in. This caused protests in Port-Louis, the capital of Mauritius. As you can see from this photograph, these children greeted a British minister, Bill Rammell, with placards and claims. And that was how matters remained until 2010. Then, Foreign Secretary David Miliband announced that Britain would establish a Chagos Marine Protected Area, over 250,000 square miles. The MPA, as it was called, would protect oceans and biodiversity, and it would burnish Britain's green credentials in the run-up to the spring 2010 general election, and cast a rather more favourable light on Chagos than that which had grown following news about its use in Iraq and for torture and the war on terror. The MPA would ban fishing and all human activity, and it would double the world's coverage of protected oceans. It wouldn't apply, of course, to the US base at Diega Garcia. Mr. Miliband stated, "The United Kingdom takes its international environmental responsibilities seriously." Conservation groups were totally thrilled. The Zoological Society of London, patron Her Majesty the Queen, hailed the proposal, as did the Chagos Conservation Trust, along with international groups like Pew and the Bertarelli Foundation. A historic victory for global ocean conservation, they declared, but they were totally silent about the Chagosians, who were understandably deeply disturbed by the announcement about the use of their lands. The government of Mauritius was equally concerned, for just a few months earlier at the Commonwealth Heads of Government meeting, CHOGM, Gordon Brown had assured Mauritian Prime Minister Navi Ramgoolam that Britain would not act unilaterally. As Port-Louis pondered its options, WikiLeaks unloaded millions of pages of top-secret US documents, several of which related to Chagos. Of particular note was a 2009 cable from the US Embassy in London to Washington on the MPA. The document recorded the views of one Colin Roberts, Director of Overseas Territories at the Foreign Office. He extolled to the Americans the virtues of Mr. Miliband's plan, not least because it was modelled on American sanctuaries in Hawaii and the Marianas, and would create the largest marine reserve in the world, prohibiting all human activity, except, of course, on and around the base at Diega Garcia. And the proposal would create no difficulties for the local population because there was no local population, Mr. Roberts added. "We do not regret the removal of the population," the cable reported his words. So there would be no human footprints, no Man Fridays on Biot's uninhabited islands. And he went on. The marine park will put paid forever to resettlement claims of the archipelago's former resident. Those are Mr. Roberts' words. Marvellous. Environmental protection harnessed to stop the Chagosians from ever going back. This was a document of the kind that stiffens the backbone. The Chagosians lodged a new case at the High Court, Banku number 4, challenging the MPA on the grounds that its true unstated purpose was to prevent the return of the Chagosians. The case would eventually be rejected, like many others, by the Supreme Court here in London, but not before it threw up, in the process of discovery and in open court, a raft of remarkable government documents that shone a bright and terrible light on Britain's actions between 1963 and 1973 behind the scenes. By now, KPMG, the consulting group, had reported that a return by the Chagosians was feasible. Artisanal fishing, small coconut plots and ecotourism could provide jobs, and the return of the Chagosians would have no adverse environmental effects. But the British government decided against resettlement for reasons of feasibility, defence and security interests, and cost. The Chagosians mounted another legal challenge, Banku number 5. Leave for appeal on that case is today pending before the Supreme Court. Mr. Miliband's announcement prompted Mauritius to consult lawyers, and I became part of a legal team that was tasked with challenging Britain's actions under international law. Options were limited because the FCO had closed off the possibility of Mauritius suing Britain directly at the International Court in what's called a contentious case. So the path chosen was the UN Convention on the Law of the Sea and arbitration to obtain a ruling that the MPA was illegal. Because, firstly, Mauritius hadn't been consulted, and secondly, because the United Kingdom was not the coastal state and had no right to declare an MPA in the first place. Mauritius was the true coastal state. The path of justice is not speedy. 3 years of pleadings and preliminary skirmishes, a hearing in Istanbul at the Pera Palace Hotel, no less, where Agatha Christie wrote Murder on the Orient Express, and then an arbitral award. It was now March 2015. The 5 arbitrators ruled unanimously that the MPA was indeed illegal. Britain had violated its obligations to Mauritius under the law of the sea on fishing, marine resources and seabed minerals, and it had not properly consulted with Mauritius. On the other hand, by a majority of 3-2, the tribunal found it did not have jurisdiction to decide which country was the coastal state. The majority ruled the tribunal could not, as a law of the sea tribunal, express a view on sovereignty over land or the effect of Resolution 1514 and the principle and effect of territorial integrity. But, and this was important, 2 arbitrators disagreed. They thought that the arbitral tribunal could decide who was the coastal state, and they ruled for them, although it was not effective and binding, that Mauritius was the coastal state. In 1965, they wrote, Mauritius had not consented to the detachment. Harold Wilson's Frighten Them with Hope was duress. So the whole enterprise was illegal and without any legal effect. The 2 dissenters, distinguished lawyers, Judge Kateka of Tanzania and Judge Wolfram of Germany, had opened a new door. Their dissent, and the fact that the majority said nothing to support Britain's claim on the merits, caused Mauritius to ask once more, is there a route to The Hague, to the International Court, the UN's principal judicial organ, sometimes called the World Court? There was. The ICJ can give advisory opinions to the UN General Assembly. In 2010, we'd advised against this option because we were concerned about the prospect of persuading a majority of UN members to vote against the US and the UK, permanent members of the Security Council. But circumstances had changed. 2 arbitrators had now ruled in favour of Mauritius's claim, and none had spoken against it. And then, as if by magic, Britain voted to leave the European Union. As ministers waxed lyrically about a new Empire 2.0 and future alliances with Commonwealth countries, the reality was brutally different. Britain's international authority collapsed, and it did so instantly. This became apparent that summer in UN General Assembly General Committee, a body of 26 members, which is able to place the Chagos issue on the agenda of the General Assembly. Without EU votes or lobbying, Britain no longer had a majority. So it was decided by the General Committee that if Britain and Mauritius couldn't resolve their differences by 2017 in June, the possibility of an ICJ advisory opinion on Chagos would reach the floor. There were talks over a year, but no progress. In June 2017, the General Assembly debated Chagos, and it decided to schedule a vote on a request for an advisory opinion. A draft resolution was circulated on behalf of the 54 members of the group of African states. This is the first time ever that all 54 African countries have voted unanimously on something. And it was supported by the non-aligned movement. Britain opposed the resolution, obviously, supported by the US, whose ambassador, Nikki Haley, warned that it would be inappropriate to seek an advisory opinion on what was, she said, a bilateral dispute. It would set a dangerous precedent. I travelled to New York to lobby with the Mauritian team, as Britain warned that the UN was being used as a backdoor route to the court and that it would compromise the judicial institution. I spent many hours seated at a small table in the Indonesia lounge, known to some of you, meeting delegates from dozens of countries, about 40. Mostly legal advisors, some happened to be my former students. Over a full day, only 2 delegates, a genial Australian and a rather sensitive Canadian, expressed any inclination whatsoever to support Britain, albeit with little enthusiasm. Most delegates I met were from Africa, Asia, and the Caribbean, and none, not one, were hostile to Britain. All described pressure to vote against the resolution or abstain, but not one suggested they would succumb. Many spoke of Britain's continuing colonial instincts. Many spoke about Britain's racism. Many spoke about Britain's patronising, entitled, hubristic attitude. And I learned a lot that day. I learned about the gap between how Britain sees itself and how most other countries of the world see Britain. I learned about the decline in authority, and I saw the eyebrows raised when the name of the then British Foreign Secretary came up. For his articles, replete with their racist epithets, and his recent public racially charged put-down of President Obama were widely known. They didn't go down quite as well in New York as they do with the readership of the Daily Telegraph. With the vote, the General Assembly's membership board lit up. Look for the red spots. That is support for the United Kingdom. Green is in favour of the resolution, send the question to The Hague. Yellow is abstention. Black is absence from the voting chamber. Red is support for the UK. Resolution 71292 passed with a big majority. 94 in favour, 16 abstentions, 16 against, 65 abstentions, including, interestingly, China, Russia, and France. Only Croatia and Hungary of the entire EU supported Britain, together with just 3 of the 54 members of the Commonwealth. Not one country from Africa, Latin America, or the Caribbean voted with Britain. Global Britain, not really. The General Assembly sent the 2 questions to the International Court of Justice. The first asked whether decolonisation had been lawfully completed, given the detachment of Chagos. The second addressed the consequences if the court ruled the detachment to be illegal. The case had a name: legal consequences of the separation of Chagos from Mauritius in '65, and a timetable: 2 stages of written pleadings, followed by hearings. By the time the case was heard in September 2018, Britain had now lost its judge on the International Court. It had had a judge since the court was created by the League of Nations, 100 years earlier. He was defeated in a closely fought election by a candidate from India, and that was a consequence of the toxic combination of Iraq, Chagos, and Brexit. The first to address the court when the hearings opened was Sir Anirudh Jugnauth, who was the last living survivor of the Lancaster House Conference in 1965. And that first morning, the judges watched Madame Élysée's video, the one you've seen. She was there, sitting in the front row, and they watched her too. Britain followed, led by its Solicitor General. Normally it would be the Attorney General, but Mr. Cox was conflicted. He had actually given advice previously to the Mauritius government that fully supported its claim. Mr. Buckland set out the British arguments. The court should not exercise its jurisdiction, and in any event, the detachment was perfectly lawful. The Chagosians, yes, indeed, the manner of their removal was shameful and wrong, Mr. Buckland said. And I've learned to pass the drafting of British lawyers and civil servants very carefully, but not, he was effectively saying, the fact that it had occurred. Madame Elissee's words were very moving, and he expressed his personal deep respect to the Chagosians, but nothing more. No commitment to the right the wrong, no concession on a return. Compensation was paid. That was immense enough. 23 countries participated in the hearings. The UK and the US were supported by just Australia and Israel. As pretty much the rest of the world, every continent supported Mauritius. South Africa, I thought, spoke with a special authority. For 5 decades earlier, it had been in court adopting the position and arguments now being articulated by Britain and had lost in respect of its illegal occupation of Namibia. As a former colony, Counsel for South Africa said, we know all about colonialism and deportations and their continuing effects. And we know what it means when entire communities are taken from their homes on the basis of race. There is no such thing as part freedom, she said, and decolonisation can never be partial. The line, in fact, came from Nelson Mandela, whose bust stood on a pedestal right outside the Great Hall of Justice. The court gave its decision in February 2019. It had jurisdiction, it ruled, and there were no reasons not to exercise that jurisdiction. It had all the facts it needed to rule. The issues decided by the earlier arbitral tribunal in the MPA case were different, so the principle of res judicata didn't apply. The General Assembly's questions were about decolonisation. It was not a bilateral dispute about sovereignty, as Britain argued. The court cannot decline to give an opinion. Just 2 of the 14 judges dissented on the question of whether it had and could exercise jurisdiction. On the merits, the facts were clear. The British and Americans discussed, an agreement was reached, Chagos was detached, and independence followed. The Chagosians were forcibly removed. Was decolonisation completed? No, it was not. Resolution 1514 reflected the law in 1965, and international law prohibited the disruption of the territorial integrity of a country without its consent. Did Mauritius consent? No, it did not. The detachment of Chagos, the court ruled, was not based on the free and genuine expression of the will of the people concerned. The detachment was unlawful. A new colony was created. The decolonisation of Mauritius remained incomplete. And what were the consequences? The court went on. Britain's occupation of Chagos is illegal, and its continued administration is a wrongful act. The court declared that Britain must end its administration as rapidly as possible, since Chagos is part of Mauritius. The court then passed the baton to the General Assembly to decide on the modalities, including on the future of the Chagosians. On the merits, only a single judge dissented. But, as she said, the American, this was not on the merits. She offered no support to the United Kingdom. Not a single judge did. 3 months later, in May 2019, the General Assembly adopted Resolution 73295. This welcomed the court's opinion, affirmed Chagos was an integral part of the territory of Mauritius, and ordered Britain to withdraw its colonial administration within 6 months, by November 2019. The Chagosians could return as a matter of urgency. The UN, its members, the specialised agencies, and all other international organisations were bound to recognise Chagos as part of Mauritius, and they must henceforth ignore any measure purportedly taken by the United Kingdom on behalf of the British Indian Ocean Territory. The resolution obtained an even bigger majority. Support rose to 116 countries, and those voting against fell from 16 to just 4. You can see the little red dots. There are very few of them. Embarrassing, the New York Times would report. The British ambassador offered a last word. Depleted, crumpled, apparently tearful, she dissembled. Britain remains firmly committed to self-determination, she said. but not on this issue. Instead, horrifyingly, she evoked the Falkland Islands. No sovereignty discussions until those islanders so wish, she told the General Assembly of the United Nations. It was incredibly awkward. Many in the room heard her to be saying that there was one rule for the whites and another for the blacks. So what happened next? The advisory opinion and the General Assembly resolution coincided with the dying days of Theresa May's government. It landed in Foreign Secretary Jeremy Hunt's inbox. Whitehall advisers offered two options. The realists proposed that Britain, the US and Mauritius should sit down and sort the matter out together on the basis of the legal ruling. The government may not like the advisory opinion, but it was what it was. Britain would have to live with it if it believed in the rule of law. And in any event, Mauritius had very publicly and formally committed to the continuation of the US base at Diega Garcia, so there was no issue of national security. The fundamentalists, pushed by the National Security Advisor, believed Chagos was so indispensable to national security that Britain should simply ignore the ruling, hunker down, and carry on as though nothing had happened. And it was the latter view, I'm sorry to say, that prevailed. The government said the court was wrong and that Britain had no doubt about its sovereignty. The court should not have exercised its jurisdiction. It had erred on the law and the facts, and in any event, the advisory opinion was not binding as such on the UK. No, the Chagosians could not go back. The US offered support. Mr. Trump declined the offer of a long-term lease. Messrs. Johnson and Mr. Raab continued that policy, and it remains the position of the British government today, including apparently with the new Foreign Secretary. The Labour Party, the SNP and other political parties have all made it clear that they would return to Britain's traditional position of respecting the rule of law, and they would honour the ICJ decision and recognise the right of the Chagosians to be able to return. The government's approach makes Britain an illegal occupier of the territory of Mauritius. It is no different from South Africa in relation to Namibia after the ICJ's advisory opinion in 1971. So is that the end of the matter? It is not. The advisory opinion has had legal effects for the UN and for the General Assembly and for the rest of the United Nations. Consequently, the UN has changed its map of the world. As you can see, it now shows Chagos as part of Mauritius, not disputed, not claimed by any other country. Legal advisors of the UN and its specialised agencies have all committed jointly to implement the ICJ advisory opinion and the UNGA resolution. The Food and Agriculture Organization of the United Nations in Rome has declined to recognise Britain's claim to be the coastal state of Chagos for fisheries purposes or for the deposit of a treaty. The Universal Postal Union has recognised Chagos as part of Mauritius and recently ruled that it will not register, distribute or forward any postage stamp issued by the territory formerly known as the British Indian Ocean Territory. All references to Biot have been removed from the UPU arrangements. The ruling is legally binding, and it means that those lovely Biot stamps, the one I started with at the beginning, with a portrait of a fish and of Her Majesty the Queen, can no longer be used, although you wouldn't know that if you went onto the website of the Biot Post Office. The other specialised agencies are going to follow suit. We can expect, for example, the ITU to resolve that UK-authorised telecommunications services operating from Chagos are unlawful. We can expect the International Civil Aviation Organisation to decide that the UK has no right to regulate flights in and out of Chagos or over its vast, vast territory, and so on. Step by step, it will be a war of attrition. Britain will have to confront the world as it is, not the world as it would like it to be. And other international bodies are following suit, including courts. The International Tribunal for the Law of the Sea in Hamburg has recently ruled that the ICJ advisory opinion, contrary to the British government's position, does have legally binding effects, and that Chagos is part of Mauritius and that Britain has no claim whatsoever How did that happen? One of the very few countries, the red dots, to support Britain in that second resolution was the Maldives, leaned on apparently by the British government, which happens to share a territory, a maritime boundary with Chagos. After Resolution 73-195, the second one, Mauritius invited the Maldives to negotiate a maritime boundary with it. The Maldives declined. It said the UK had a claim. So Mauritius sued at ITLOS, and it invited the tribunal to delimit the maritime boundary. The Maldives objected to the tribunal's jurisdiction. You can't delimit a territorial boundary dispute, it argued, and it cited the earlier MPA arbitration. Not at all, said ITLOS. The situation has changed. There is no longer a dispute over sovereignty. The 9 judges ruled. The ICJ has definitively resolved the matter. Its determinations in the advisory opinion have legal effect, the tribunal concluded, and Britain's so-called claim is contrary to those determinations. It is, in other words, worthless and meaningless. London can blabber on, but it will have no effect in the courts of the world. And right now, the tribunal is proceeding to delimit the maritime boundary between Mauritius and the Maldives. The UK has no role. What is Britain's reaction to all of this? It has simply chosen to bury its head in the sand and hope that the facts and the problem will somehow just go away. Following the ITLOS judgment in January of this year, Mr. James Heapy, a junior minister at the Ministry of Defence, repeated the government's mantra, "We have no doubt about our sovereignty, blah, blah, blah." Britain may indeed have no doubt, and one wonders what exactly the lawyers at the MOD and FCO are actually advising these days. But focus on the reality. 28 international judges and arbitrators have in the past years had an opportunity to address Chagos, and not one of them, not a single one, has expressed support for the United Kingdom claim. 23 have concluded that Mauritius has sovereignty over Chagos, and the other 5 have simply expressed no view on the merits. They've just said, we don't have jurisdiction to decide. Britain has made its arguments, and it has not managed to persuade a single international judge anywhere in the world. But Mr. Heapy went even further. The ITLOS judgment, he said, has no effect for the United Kingdom or for the maritime delimitation between the United Kingdom in respect of Biot and the Maldives. That is what he told Parliament. It is astonishing for those of us who are used to British respect for the rule of law, including at the international level. Really? Does that mean that London is now preparing to negotiate its own maritime boundary with the Maldives in parallel to the one delimited by the International Tribunal for the Law of the Sea? Curiouser and curiouser, it might be said. Britain in Wonderland. The government's position is totally hopeless. And across the world, there is simply incredulity. What happened to the country that believed in the rule of law and multilateral rules and international courts? I am frequently asked in my capacity as an international law academic. What happened to respect for international institutions? But, as many of you know, the position on Chagos is part of a bigger picture, one in which the present government treats judges and lawyers, wherever they are, with absolute contempt, and sees international law as a horrible inconvenience, and believes that international agreements, like the Northern Ireland Protocol to the Brexit Withdrawal Agreement, can simply be torn up and shredded at will. A huge price is being paid for this. British trust and credibility are shot to bits. A recent foreign policy paper, Global Britain, it was called, signalled a shift away from Europe and towards the Indo-Pacific region, our new neighbours. In it, the government boldly asserted Britain's, and I quote, absolute commitment to upholding the UN Convention on the Law of the Sea in all its dimensions, end of quote. That's this year, it's after the ITLOS judgment. Absolute, yes, maybe, but just not in relation to Chagos or the Indian Ocean. The world is a small place these days. Beijing and Moscow just laugh at Britain. Europe weeps and others just feel embarrassed. President Biden has called the rule of law one of America's most cherished democratic values. It's a riposte to the Trump administration, a useful stick with which to beat China on the South China Seas and Russia on Crimea. Secretary of State Antony Blinken has recently castigated Beijing for making unjustifiable maritime claims in the South China Seas, for violating the law of the sea and rulings of an international law of the sea tribunal. I was counsel for Philippines in that case against China, which China has ignored. The Biden-Blinken position of principle is undermined by its support for Britain on Chagos. One act of lawlessness does not justify another. If you want to weaponize the rule of law, you've got to be damn sure that your own house is in order first. As the great Aimé Césaire reminded us in his discourse on colonialism, a civilization that plays fast and loose with its own principles is a dying civilization. The government is not entirely alone in its little wonderland. It has some support from business and from various other bodies. A Guernsey-based, Bahrain-owned telecoms company called Shaw will sell telephone, broadband and other services to those currently living on Chagos and to nearby mariners, but it will do so without the benefit of a license issued as required by the authorities of Mauritius. That makes it a criminal offence in Mauritius, for Chagos is part of Mauritius, punishable by a fine not exceeding 1 million rupees and to penal servitude for a term not exceeding 10 years. Football supporters amongst you will be familiar with advertisements and hoardings for a betting company called sportsbet.io. Have you ever wondered what .io stands for? It stands for Indian Ocean, nominally assigned to the British Indian Ocean Territory. The .io domain name is highly popular with tech companies, and it is much more expensive than other domain names. Someone is making a lot of money out of that domain name, and they are doing so completely illegally. There is a question as to whether any of that money is making it into the coffers of the United Kingdom government. And of course, it is all without the authorization of Mauritius. The Pobjoy Mint down in Surrey continues to issue and sell Biot coins. And one wonders whether Buckingham Palace is aware that the Queen's portrait, alongside the Chagos anemone, also known as the clownfish on the other side, is being used with such lawless abandon. The Zoological Society of London, patron Her Majesty the Queen, is deeply proud of its conservation work in Chagos, but it continues to totally ignore all the international rulings and will not engage with Mauritius. Still today, it issues reports and sends out scientific expeditions that wrongly and unlawfully treat Chagos, still today, as part of Britain. This is the website. I last accessed it this morning. It describes Chagos as part of Britain, one of its 14 overseas territories, one of the most amazing marine environments anywhere in the world. And it proclaims its work with the Bertarelli Foundation, exemplar. It touts its team of 50 researchers from 14 institutions across the world, studying all aspects of the animals and habitats of this amazing place. And all of this is totally illegal under international law, supported by the Foreign Office, and you know nothing about this if you go onto its website. The FCDO has retained the services of another British company, MRAG, M-R-A-G, to provide scientific and technical advice on the management of the waters of Chagos and the illegal marine protected area. MRAG provides the single vessel that patrols 250,000 square miles of Chagos waters. Incidentally, in the MPA arbitration, it emerged as an uncontested fact. It was an internal British government document that the principal source of pollution in the Chagos archipelago was the British patrol vessel. You could not invent the situation. And guess what? The executive chair and founder of MRAG just happens to be, the president of the Zoological Society of London and a former chief scientist to the British government. Lawlessness is safer in numbers, it might be said, and far, far cosier. Let me be clear, speaking personally, such marine conservation work is hugely important, and I would fully and totally support it if it was done lawfully. I've taught international environmental law for 30 years. To be lawful, it has to be authorised by the authorities of the only country in the world recognised under international law to be sovereign over that area, and that is Mauritius. All the Zoological Society of London and the other bodies need to do is ask for permission. All the scientists need to do is ask for permission. All the foundations that may be thinking about giving money to give grants to support such work need to do to ensure that that work proceeds is ask the permission of Mauritius, which supports environmental conservation in the area. But the illegality of these activities raises another possibility, and I raise this point with some trepidation. Britain's illegal occupation of Chagos, with the support of companies like Shaw and sportsbet.io, reputable organisations like the Zoological Society of London, the Conservation Trust and the Bertarelli Foundation, all of this work is what is preventing Madame Élysée and all the other Chagosians from returning to the homes from which they were forcibly removed 5 decades ago and to which they wish to return. Business, science and conservation are, in effect, being harnessed to support an act of major international wrongdoing. And it was all planned. The 2009 US cable to which I referred made the point more clearly than I can. The environmental lobby is far more powerful than the Chagosian advocates, Mr. Roberts told the Americans. You, the ZSL and the other organisations, are being used to maintain an illegal occupation. The environment is being used to trump the rights of Madame Élysée and others. Those engaged in authorising or engaging in these activities, prime ministers, foreign secretaries, national security advisors, cabinet secretaries, the civil servants at FCDO and MOD and BIOT, all of them, the trustees of the Zoological Society of London, the Chagos Conservation Trust, the Bertarelli Foundation, and all the others, and each and every scientist conducting research, and so many other people involved, may wish to reflect a little on their association with such international illegality and on the human consequences of their decisions and acts. Why? Because international law treats the forcible deportation without lawful cause as an international crime. As I described in East-West Street, when Hirsch Lauterpacht put the concept of crimes against humanity into the Nuremberg Statute and international law in its Article 6C, which you can see on the screen, he and Robert Jackson, the chief prosecutor, included deportation as a crime against humanity, the forcible transfer of a group from one territory to another. The 1948 Universal Declaration on Human Rights recognises that each of us has the right to return to his country. The 1949 Geneva Convention explicitly prohibits the forcible transfer of any individual or groups, or their deportation from one territory to another. And more recently, Article 7 of the Statute of the International Criminal Court, adopted in 1998, incorporated into English law, defines a crime against humanity to include the deportation or forcible transfer of population. Leading counsel has already prepared a legal opinion which concludes that it is more than strongly arguable that the forcible removal of the entire population of the Chagos archipelago was a crime against humanity. The refusal to allow them to return to their homes is also a crime against humanity, and there is recent authority for this proposition, directly on point. In November 2019, 3 judges at the International Criminal Court in The Hague authorised the ICC prosecutor to investigate the refusal of Myanmar to allow any Rohingya to return from camps in Bangladesh to their homes, on the basis that this refusal amounted to a crime against humanity. And right now, Human Rights Watch is deeply examining the Chagos situation under the lens of international criminal law. The mistreatment of the Chagosians is a continuing act. It is not a historic matter. What began with forcible removals in the late 1960s continues through the maintenance of the expulsions over 5 decades, to the refusal to allow them to return, all the more so following the clear determinations by the International Court, the Hamburg Tribunal, and the General Assembly. So what is to be done? This actually can be rather easily sorted on the basis of the law. There is a simple solution, one that addresses all of the intertwined issues that are at stake: the territorial integrity of Mauritius, the protection of the environment, the maintenance of national security interests, and the rights of the Chagosians. Mauritius, Britain, and the US have close and excellent relations, and India can play an important role. The sovereignty of Mauritius over Chagos is now a given in international law. That ship has sailed. It is recognized by international courts and tribunals, by the UN, by organizations, by just about every single country in the world. Mauritius has long made clear that it supports the US base at Diega Garcia. It has offered the United States and Britain, if it wants to participate, a 99-year lease over Diego Garcia, one that would provide long-term security lacking under current arrangements, which are unlawful and which expire in any event in 15 years. And it has offered a role to Britain if Britain wants one. To the extent that China is seen to pose a threat in the area, the military base is the answer to that question. And Mauritius has also made crystal clear that it supports continued marine conservation for the whole of Chagos, that it would like to work with the British government and with bodies like the Zoological Society of London and the Chagos Conservation Trust and others. Indeed, it has entered into such an arrangement with France for the environmental co-management of nearby Tromelin. Which leaves the Chagosians. They are a very large group with many descendants, some of whom you'll be horrified to know have been windrushed. I first met them a decade ago at a meeting which you can see here at the Royal Geographical Society. Many individuals with a range of views and hopes and desires. Many want to be able to return to the outer islands of Chagos, including Peras Banhas, or maybe to work at the US base alongside the other nationals, Bangladeshis and Sri Lankans, who work there today. The outer islands sustained human habitation for more than 2 centuries, and they can do so again today. They are empty right now. KPMG agrees. They are hundreds of miles from Diego Garcia, and they pose no security threat whatsoever. Writing for the majority in one of the Banku cases before the Supreme Court, Lord Hoffman, who is not known to be a bleeding heart, made clear that the contrary view, allowing the Chagosians to return to the outer islands, would somehow create a threat of terrorism, was nothing more than fanciful speculation. There is a win-win-win outcome. Security, human rights, the marine environment, and respect for sovereignty and territorial integrity can all be assured. The rule of law, treaties, the law of the sea convention can all be promoted. Charges of hypocrisy and double standard can be cast to the wind. This is not a zero-sum game. Britain will lower its flag on its last colony in Africa. The only question is when. The passage of time is a terrible stain on Britain's reputation and authority. It undermines its ability to challenge the lawlessness of others, and it encourages, frankly, the lawlessness of others. It promotes the view that Britain retains a colonial instinct and that it is institutionally racist. I conclude with an anecdote, an unlikely connection between Lviv, that was the city at the heart of East-West Street, my book, and Chagos. A few months ago, I received a letter from America. I'm a 79-year-old survivor of the Holocaust. I was born in Lvov in January 1942, and I came to the United States in mid-1946, the writer of the letter explained. Only 3 members of my Lviv family survived the war. The rest perished under the command of Otto Wächter, a central character in the rat line. Thank you Thank you for your book, he wrote. It has helped me better to understand who I am. We started a correspondence that has now gone on for some months, and I learned that, miraculously, he was a retired US Navy pilot. So I asked the question, have you ever been to Diega Garcia? Actually, he replied, I have, several times. We called it Boys Town back then. There wasn't much there. Tents, a mess hall, and so on. The biggest excitement was watching baby seagulls learn to fly. He sent me a couple of photographs. This is one of them, and asked me to credit his mate, Lieutenant General Steve Newberry of the US Navy, if I ever used them. So I am. Was he aware about those who'd been removed? Dimly, he responded. We knew it had once been populated, but candidly, the place's political history didn't interest us back then. But now his interest is piqued, and he wants it to be over and done with, and justice to arrive. I see the return of these islands to their original inhabitants as one of the very last stages of the decolonisation of the British Empire, he wrote. The Brits always were high-handed in dealing with colonial people. Just look at American history for an example of that. Plus ça change, plus c'est la même chose. In the meantime, Madame Élysée waits patiently and with great dignity for the rule of law to run its course, for London to do the right thing and to be able to return home. Thank you very much.
Thank you very much, Professor Sands. An illuminating discussion and an enlightening view in terms of both the position of law and the respect of law here and how our role can be played more broadly. I think we've all learned in an incredible amount this evening, so thank you. And I certainly hope the panel discussion, which we will now start, will evolve that conversation further over the next 30 minutes or so. I want to welcome our panelists, but first I want to explain to those on the line and also in the room the structure we will evolve. Obviously, this is a hybrid event. We have people who are listening in online. If they want to ask a question, they'll see a dialogue box. They can pop a question in there, and we will get to those which I'll be moderating. But I want to, first of all, invite our panel, which will be ably chaired by someone very well known to you, which is Gideon Rachman, who's Chief Foreign Correspondent of the Financial Times. Gideon will be chairing also and feeding the questions from the room, so if there are questions, please do raise your hands. But introduce our panel, and I won't dwell on the biographies. They are in the booklet and they are on our website on the event page. I want to welcome many of those who've travelled from far afield to join us today, but all experts in their respective specialisms, from human rights to decolonialism, and to rights for indigenous populations. And they're all going to, again, give us their views and their take on Professor Sands' discussion over the next few moments. So if I'll ask you to join us on the stage, Professor Bonnie Ibawa from the University of Ontario, Dr. Jeannie Moorfield from the University of Oxford, and Professor Colin Sampson from the University of Essex, and Gideon as well. I'll welcome you to join and take a seat. Professor Sands, if you can stay with us and take a seat. And thank you very much. Gideon, over to you.
Thanks very much. So, thank you very much, Philippe. That was an absolute tour de force. There are not many 45-minute lectures or however long it was that keep your attention absolutely, and it really did. I think you ran over, but although people threatened to haul you off, I don't think anybody had the courage to do that because it was really so compelling as a presentation. We are a bit over, but let's just run on at least till 8 o'clock. I think everybody would like us to do that. So, I'm not going to play a very complicated role. I'm just here to kind of steer the traffic, really. And I think we have 3 academic experts who deal with aspects of this issue in different ways. So I'd just like to really ask them for their responses to what Philippe Sands had to say and to the whole case of the Chagos Islands. Professor Ibawa, do you want to go first? What do you make of this case? What does it mean to you?
Yeah, first I want to say thank you. The Chagos case may not be familiar to many people here, but I can assure you that in certain constituencies this has always been a hot button topic. So I thank the organizers for letting me preach to the congregation, not just the choir this time. But coming back to the question, Chagos for me essentially is an illumination of the history of colonialism. I teach international human rights, and when I teach my students, the questions often arise. How could these colonial atrocities have happened? What were the sensibilities of the time? How was this rationalized? And my default answer is look at Chagos. You look at Chagos and you see a living example of how colonialism could have happened. Chagos also underscores the transactional nature of colonialism, that this is trading, Britain, trading with the United States, making this concession to the United States without regard for the people and the land. And you can go back, whether you're talking about the Royal Niger Company in the West Africa, where the assets of the Royal Niger Company were bought over, with what became the United African Company in complete disregard of the wishes of the people, or Herero, or King Leopold's Belgium. So there's so much in Chagos that mirrors the deep history and the complicated history of colonialism. So for me, it really reflects so much of these issues that we talk about that sometimes feel like an anachronistic past. And it helps us understand how real these issues are.
Thanks very much. And Dr. Moorfield, I know you've looked particularly at the sort of Anglo-American aspects of this and how the British and the Americans have simultaneously presented themselves as champions of liberalism, human rights, and so on, and yet in this particular case are defending a colonial legacy. How do you explain that?
So I actually think that Britain, while it was a colony, also thought of itself and used the language of liberalism. And in a lot of ways, American power today is imperial, is deeply imperial. The US has more bases and military personnel abroad than any nation or empire in history. So in some ways, this is all about the way that global hierarchy is still imperial in essence, and yet uses a language of human rights as cover for that. And when something like Chagos comes up, and again, I just want to say thank you so much for this amazing talk. It both highlights the way that you have these residual colonial aspects to that hierarchical order, and yet at the same time should be taken as, I think, par for the course. So in effect, spots of violence like this existed all over the world since the post-war period. And I think we need to take this as both an example and an exception.
Okay, and Colin Sampson, I know you've worked again similarly on these kinds of issues. How do you see Chagos illuminating the kind of work you've done?
Yeah, I think it illuminates a number of things. First of all, I'd also like to, congratulate Philippe on his work. And my first reaction is, wow, what a powerful speaker, and what an authoritative and well-composed speech he gave. One of the things that he was saying right at the beginning was that Britain is not good at engaging with with colonialism, and I think there's a very good reason for that, because there's a rather schizophrenic attitude that pervades Britain, and particularly the British state. So on the one hand, you have effusive proclamations to adhere to the rule of law, democracy, and human rights, and then on the other hand, you've got complete impunity towards these, and I think that does actually that does engender a kind of a schizophrenia. So how it affects my work is I wrote a book called The Colonialism of Human Rights, in which I was interested in the connections between human rights and colonialism, and I started the book off with something that actually Philippe didn't mention, which is that on the day of the ICJ ruling in 2019, the British representative at the Human Rights Council, Lord Ahmed of Wimbledon, announced that Britain would be reapplying for membership of the Human Rights Council on account of, quote unquote, the rising tide of impunity around the world. This was on exactly the same day. So I think it speaks in a way to this incredible, I don't know what dualistic psychology in Britain. I witnessed it myself when I attended the deliberations on the UN Declaration on the Rights of Indigenous People in Geneva. That was passed in 2007. And I got the opportunity then to speak to representatives from Canada, the US, and Britain, and they were all slightly different. But what was interesting about the British representative is a number of things. One, and I think this is shared with the Chagos story, one was secrecy. There was a reluctance to really say very much about what Britain's position was. But it was very clear that Britain would not entertain any kind of historical perspective. They were not really interested they were only interested in looking at a snapshot of the present to determine indigenous people's rights. They weren't interested in the past. And they were generally opposing the declaration. In fact, they led the opposition for some time. And only when it was passed in 2007 did they abstain. And when they abstained, they listed so many objections to it as to basically make it absurd. So I think the kind of the cultural pattern that you identified in your talk, and that I think that Chagos illustrates, is part of a wider scene. And the other, okay, I think I'll stop there.
Thank you very much, Colin. And I would just like to point out, I'm now going to walk off the stage. This is not an act of disgust. It's just that I left the iPad. They're going to send me questions on that tab, so I'm picking it up. But first of all, actually, I'd like to ask for questions from the floor. I mean, we've got a lot of experience here. Indeed, a few people who've worked in the British government, even on this issue. I asked a couple of them earlier if any of them could defend this, because I think it would be interesting. We need somebody to put the opposite view. So I think we have a former High Commissioner in Mauritius. So, sorry, I missed your name. If you can say.
I will. My name's David.
Your microphone is coming your way.
Where's the microphone?
Thank you. My name's David Snoxall. I'm the coordinator of the all-party parliamentary group on the Chagos Islands, (BIAT). I started my career in 1969 as a UK delegate on the Decolonisation Committee of 24 in New York at the General Assembly. Later on, I was to become the Deputy Commissioner of the Chagos Islands, or BIAT, and my last posting was High Commissioner to Mauritius, where I spent at least a third of my time on dealing with the outfall of everything to do with Chagos. That said, may I just say to Philippe, that was remarkable and masterful as usual, Philippe. I go along with 98% of everything you've said. The 2% I'll save for another time, and I'll point that out. Right. Could I, as it happens, just before I arrived, Lord Ahmed of Wimbledon answered a parliamentary question, and from Baroness Whittaker, who would like to have been here. Baroness Whittaker is one of the vice chairs of the all-party parliamentary group. She had, if I can hold the microphone and at the same time, oh, thank you very much, because I think this will bring you up to date on, yes, well, I'm getting closer. Right. The question was to ask Her Majesty's government what plans they have to hold discussions with the government of Mauritius in relation to a settlement concerning the future of the Chagos Islands, which will, one, allow Chagosians to return to the islands, and two, safeguard the future of the UK military base on Diega Garcia. I would only comment that the Table Office clearly missed out the last very important sentence, which was in accordance with human rights and international law. Right. The answer, which was given a couple of hours ago, was from Lord Ahmed, there are no current plans for discussions with the government of Mauritius on the future of Biart, which will allow Chagosians to return to the islands. We remain open to dialogue with Mauritius on matters of shared interest, including Biart and its marine protected area. The defence facilities on Biart help to keep people here in the United Kingdom and around the world safe. The UK will cede sovereignty of the territory to Mauritius when it is no longer required for defence purposes. Thank you. Well, I would only comment the Lancaster House Agreement of 1965 used the word return, not cede. Cede was an invention by legal advisors some 10 years later because it seemed to strengthen Britain's claim to sovereignty. May I just say one more thing, because I know I'm taking up rather a lot of time. You may all be wondering what on earth has Parliament been doing over the last 50 years on this issue. Well, 40 years ago, at least, Jeremy Corbyn and other members of Parliament asked parliamentary questions and intervened in various debates. This was following revelations in the Washington Post. In 2008, Parliament set up an all-party parliamentary group. I was invited to be the coordinator. We had our 85th meeting last week. We have issued many statements. We've corresponded with the Foreign Secretary and with the 17 ministers that we have connected with, 17 ministers from 2000 to today who were responsible for the overseas territories. There is a complete brick wall, as the answer to that parliamentary question shows. Parliamentarians continue to do the best they can. There are 55 members of both houses, and they represent the 7 political parties in Westminster, the only parliamentary group to have members from all 7 political parties. So I just want you to know, Parliament has a very different view from the British government. I have rarely met a member of Parliament who actually supports the British government's position. There is one, and there was a Whitehall debate, a Westminster Hall debate only last week on China, in which he raised Chagos, and I'll leave you to find out what he said in support of the British government.
Thank you. I know Jean wants to say, could I just ask you a very quick question, though? Because I'm intrigued, listen to you. I mean, you were High Commissioner in Mauritius.
Yes.
Presumably you had to defend all this stuff throughout your career. So when did you change your mind?
I never did change my mind. I've always strongly supported the Chagosians, and I think it was quite brave of the Foreign Office to send me to Mauritius.
Well, like a massive contradiction of their own foreign policy.
Well, no, we're quite broad-minded, actually. Well, may I just tell you that the present High Commissioner is of Creole descent, from Mauritius herself. This is the first female High Commissioner we've had. She went there in August, and she speaks Creole. Now, I find that quite amazing that the Foreign Office have appointed her to that role.
But presumably she defends the British government line.
Well, it's not so much defending the line, it's representing British government views. And everybody knows there is a difference between, especially when you call on the Foreign Secretary or Prime Minister, there is a difference between saying, we think this, and saying, the British government thinks this. And I always used the other formulation, and I'm quite certain the Mauritian government knew exactly what I thought.
Fine.
There are ways of communicating that, you know.
How very interesting.
Without saying it.
Interesting profession. Jean?
Yeah, no, I just wanted to bring up that your experience raises this really good point, which is that Britain and America are 2 liberal democracies which have very little democratic control over their foreign policy. And in both countries, in the US, in the executive branch, and here in the government, it's kind of sealed off from democratic oversight. And I think that's one thing that might need to change if something like Chagos is going to change.
when I went to the Foreign Ministry to tell the Minister about those orders in Council of the 10th of June 2004, as I entered the building, I ran into the US ambassador coming out, and he said, "Gee, David," he said, "I've just seen what you've done." He said, "But it's amazing, great. But you know, we could never do that in the United States. We'd never get anywhere. It wouldn't go through Senate and it wouldn't go through Congress. But here we have a system of bypassing Parliament through Tudor orders in Council." So that's how we can do it. And just while we're on the US, I would say I slightly disagree with Philippe on the point about the Americans having forced the UK to depopulate all the islands. My understanding, and I've read many of the documents, is that the US never required all the people to be removed from all the islands. They were content for them to remain on the outer islands, per Españos. And it was just simply UK colonial zeal, can I put it that way, of officials that wanted to make a clean sweep of all the people. Right. I'm sure I've spoken for far too long.
No, that was really interesting. Thank you. Professor Ibarra, you wanted to say something?
Yes, hearing a distinguished diplomat speak, I wondered about the tipping point. You go back to decolonization, the era of decolonization in the 50s and the 60s. One of the questions that many in the colonies asked is, why are those in the metropole not speaking out more? Don't they know about these atrocities? Yes, we hear a few Fabian socialists, write about, the atrocities in the colonies, but what is happening in the population? Why are we not getting more allies? And I see parallels here, that there is a disengagement. How many people know about Chagos? It's not even on the radar.
Unreported.
I see the same strategy. It's not on your radar. It is not of significance. It might be a big issue in some fringe, exotic part of the world, but that's not. And I wonder how much of that is deliberate, that you keep the population not recognizing the intensity of the case. You show beautiful pictures of fishes and, environments, and it goes away. And I think this is why it's important to try, and I don't know how you do that, bring that into mainstream conversation, because that's what tipped the scale with decolonization in the 60s. Enough people cared. And it was the work of people like Philippe Sands bringing it to the mainstream and letting people ask, questions of government to see, why is this travesty allowed to continue for so long?
Yeah, interesting point. Colin, you want to say something? Let me just see, though, if there are other people in the audience who want to ask questions. Anyone stick their hand up? Okay, Colin, then.
Just quick. I can just be quick. Just to just to try to address what Bonnie was saying there. Perhaps one of the reasons why there's been a suppression of information on this is that once this comes into the public realm, it opens the door to looking at other instances of atrocity in British colonial history that have ramifications for today. The partition of India, the things that actually Philippe mentioned, the partition of Palestine, Cyprus. I was thinking also of the forcible relocation of 57,000 people when the Zambezi Dam was built in the mid-1950s. As far as I'm aware, there's been no compensation for those people. There hasn't even been an apology or anything. So I think it opens the door to many other incidents, and that may be one of the reasons why there's a sort of a silence around this.
Okay. Very interesting question coming in anonymously on the iPad. I think probably one for Philippe. It says, hasn't territorial integrity trumped self-determination? Chagosians experience awful marginalisation in Mauritius and deserve a vote on if they want Mauritian sovereignty. And a similar question, I don't know whether it's from the same person, what are your views on Chagosians that are seeking independence from both the UK and Mauritius? Can this be pursued? And then brackets, thank you so much for the lecture.
Yeah, sure. Really good questions. Just before, I will answer that question, but I just want to come back to the discussion that's come before, because there is sort of an elephant in the room, if that's the right expression or not, and I'm prompted by what Bonnie said in particular. I mean, I've had no doubt and I'm sorry to put it in these terms, but if the Chagosians were white, it would be a completely different story. You would have newspapers absolutely going up the wazoo about the whole issue, and the fact that they are not is, I think, a part of this story, and we have to find a way to talk about that and to confront that reality. I know that folks in the Foreign Office, I've got lots of good friends in the Foreign Office, are surprised. They know all about the furore around the world, and there is now, and Britain is paying a big price around the world, but they're very surprised there hasn't been more of a domestic impact, and that's really for you, Gideon, in a sense, to pick up. But the second point in relation to this is prompted by Colin's comment, and I hinted at it. And I wonder whether I'm part of the problem in this sense, is that there is such a British obsession with the Second World War, with the Nazis, with all the terrible things that happened, that it's become a way of deflecting attention from other things, you maybe want to come in on this, and from our own horrors. And that unwittingly, by writing the earlier books that I've done, I've reinforced that tendency, and that is in itself part of the problem. Britain does not want to look at what it has done and its continuing legacy. And so the technique, or one of the techniques that it uses, is to switch attention to the horrors perpetrated by others to deflect from attention about our own horrors. You come in a moment there. I mean, I hinted at this when I showed the picture of the Chagosians. I said they're a very large group and they have a multitude of different views. As I understand it, the majority want the islands of Chagos to be part of Mauritius and to be treated as Mauritius. But there is a small minority, particularly those based in the United Kingdom, in and around Crawley, who, for understandable reasons, wish it to be part of the United Kingdom. What's the understandable reason? They've seen what's gone on with Windrush. They've seen what happens if you speak out, that you risk being deported back. I mean, irony of ironies, a number of Chagosians are at risk of being deported, unbelievably, back to Mauritius. I mean, you couldn't invent it, back to Mauritius or the Seychelles. And so I think it has that effect. And then there is a third group, which is even smaller, which says we should be a country of our own. Now, there's a political answer to all of that, and there's a legal answer, and I'm going to take refuge in the legal answer. The legal answer is that international law provides, essentially to create a regime of stability, that when a colony becomes independent, it is for the population of that colony as a whole to decide on its future direction. And the principle of territorial integrity effectively creates a mechanism in which the country goes from colonialism to an independent state as a whole. And then, as we know, parts of countries have decided to break off. We see that, for example, with Quebec, and there's a whole set of legal issues about who decides whether Quebec can leave, who decides whether Scotland is going to be independent. International law basically says the consent has to come from the entire country, not from a tiny part of a country. And that is why, whilst I listen with respect to the alternative views, I said the ship has sailed. As a matter of international law, Chagos belongs to Mauritius. Once Mauritius exercises the sovereignty that it already has, it will be for Mauritius to decide whether that should become an independent country or not. I mean, there are questions as to whether it could be an independent country, 2,000 people, but that's not for the world, and certainly not for Britain to decide. That's for Mauritius to decide.
What about allowing the Chagosians a vote on whether they would like to be part of Mauritius or the UK?
Well, that would not be possible because the rule in international, you see, this comes up with Scotland. It's exactly the same thing. You're basically asking the question, who gets to decide whether Scotland's independent? And basically, the United Kingdom gets to decide. Scotland, that's why Scotland can't have a referendum that is effective on its own, because Whitehall knows international law basically says it's for the country as a whole. And that's why you need London to say to Scotland, you can have your referendum. Same with Quebec. When Quebec had a referendum, the position in international law was, well, that referendum's all well and good, but it's for Canada as a whole to decide the conditions under which people in Quebec vote for independence, secession, whatever you want to call it. And it would be exactly the same in relation to Mauritius. It would be for Mauritius as a whole to determine under which conditions, if any, Chagosians could have their own vote. I think it's doubtful, you know, you've seen with London and with Quebec and all these things, there's a real hesitance to do that, but that's the way it works in international law.
5 minutes. All right, so we've got 5 minutes left there. Any closing?
You want
Can I
to
just say, so I read about this pretty extensively. I call it the politics of deflection,
Yeah.
back to your original point. And this, you see this in both Britain and America. Whenever they're pushed on something that looks like a violation of human rights or a crime against humanity, they'll say, yes, but remember the war? Or remember the Nazis, and this is a way this happens all the time. And my students, this is fascinating. I came to this country, started teaching in Birmingham 2 years ago, a class on the modern European political theory and empire and race. And I assumed that they would know something about the British Empire. They know nothing. They know nothing. So I said, well, what do you know about British history? And they said, well, Tudors and Nazis. I thought, okay, that's it. That explains it all, right? Between Tudors and Nazis, there's nothing.
Yeah, which is also an interesting light on the idea that the British are obsessed by their empire. I always think that actually
Well, you know,
obsessively.
Gideon, this lecture is written in the context, a book will come out about a year from now on this subject, and I've dealt with it more fully. But one of the things I did is I went back to my history book at school, just on this point. It was, some of you may remember it, Geoffrey Treece, This Is Your History. This is your century.
Yeah.
Okay? And published in 1966. I did it in 1971. I was 10, 11 years old. And there's a chapter called Sunset on Empire. And in the chapter, it has gems, awful gems, like, yes, well, India's now got its independence. I mean, this is what I've infused. India's got its independence, and we've passed from the magnificence of the Viscount who, you know, ruled over India and gave it its independence to the leadership of a small, bespectacled man who is a vegetarian and a pacifist and looks like a monkey wearing glasses.
Oh.
Go and check. This is your century.
I read that book. I rather liked it at the time. But
So when you ask why we are as we are, that is why we are, because that is what...
Yeah. Bonnie, you wanted to say something?
Yeah, I just wanted to thank Professor Sands again for bringing this to light and to make a personal appeal to everyone who's here today to go spread the word. We should leave here with what can I do. This is not just an academic exercise, as we saw in the video. This is about lives. This is about pain. This is about suffering and trauma. And I urge you to leave here today spreading the word. If it's just one person, tell them about Chagos and tell them to try to make a difference, please. Please.
Well, I think that is a very good note on which to end.
Yeah.
Do you agree, Philippe?
I'm deeply grateful to you, Bonnie, for saying that.
Oh, I think we're out of time, actually. There's somebody who'd like to ask a question, but I will kind of... Okay, yeah, quickly, go for it. Even if you do ruin our rather poetry.
Thank you for a fascinating talk. I'm Elvis Imafidon, School of Oriental and African Studies. I think the whole discussion around about Chagos, the abuse of human rights, I think we focus quite a lot on rights, forgetting that it is hinged on certain assumptions about the human and how that really plays out in how people are treated. The question of rights is also a human question. Is it that there are certain salient and assumptions about who is human by the colonizers that sort of affect how they treat the colonized in the past and how it continues to take place, because obviously Chagos is still colonized. If these persons are seen as human, would they be treated that same way? Just as you said about if it were whites, the news would be around. So are we focusing too much on the rights and just assuming that we know what it means to be human, whereas it is also a very contested issue about who is human in different contexts?
Philippe, do you want to use that for a closing words?
I mean, I really appreciate very much that line, and obviously I think about this a lot, and I spend a lot of time with members of the Chagosian community, and I'll be back with them actually in a couple of weeks. This is a really big question, you know, being in this extraordinary peace palace in The Hague at the International Court with Lisby Elise, who's, you know, nearly 70 years old, born on Chagos, expelled, goes to Mauritius. The point was made, and it's right. I mean, you know, the Chagosians have been mistreated also in Mauritius. One has to recognize that because they are black. And then she travels, you know, all the way to The Hague and appears in the court. And for her, it was, for me, it was incredibly moving, because here was an individual who was treated by the court with respect. And it wasn't about her rights, it was about her being an equal human being, and she is not used to that. As her video was being played, I was watching the other side of the room. You know, when you're a courtroom lawyer, you spend a lot of time watching what's going on, and the body language is as important as what is spoken. Watching the British Solicitor General, as Madame Elise's video was playing, watching the Foreign Office legal advisor, watching the British legal team, and the level of discomfort was immense and intense. And the level of discomfort was, and there are people here in this room who work for the Foreign and Commonwealth and Development Office, and it's very easy to deal with problems like this in an abstract, legalistic, technical way. But when you meet a human being who has been treated in this way, it changes everything. And none of the British ministers, I think it's right, David, has met any of these human beings. It's just an abstract, theoretical, distant issue. And I think, coming back to Bonnie's point, I think, and melding it with your point, they're not treated as equal. They just aren't. And that would begin to change if there was human, direct, face-to-face contact. I mean, it's curious. It makes me think immediately of a moment in East West Street when I described, it's a very different analogy, a very different anecdote, but I described the presence in courtroom 600 of two men, the Nazi jurist Hans Frank, who had been Hitler's lawyer, and defendant number 7, on the one hand, and the French judge, Henri Doniger de Vabre, who was one of the 4 judges who would decide the case. And I discovered that in 1935, 10 years before the trial began, Doniger de Vabre had been to Berlin, had given a lecture at the invitation of Hans Frank, and argued for the creation of an international criminal court. And Frank had responded and said that's a ridiculous idea. And then they went out for dinner. And the third person who attended the dinner was Julius Streicher. But when it came to the trial, and we've seen from the deliberations of the judges, the only judge who voted against the death penalty for Hans Frank was Doniger de Vabre. He couldn't bring himself to hang a man he'd had dinner with. And I think part of the problem here is the Lisby Elises of the world and the Chagosians and all the others that Colin's written about and others have written about, and Bonnie deals with in his work as special rapporteur, and you write about in your academic work. They're not really human. We don't have to deal with those people. They're just abstract. We don't have to meet them. We don't have to talk to them. We don't have to listen to them. We don't have to hear them. And there is, I think, a process of dehumanization that takes place. It's a problem of a technical nature, and we're not dealing with sentient, living, real, equal human beings. And that brings us back to what I think this is partly really about. It's the great elephant in the room. It's Britain's inability total inability, as the statues episode last summer showed, to come to terms with the issue of race and otherness and difference still today. And that is, I think, in large part a consequence of these terrible acts, not just from 50 years ago, but from 150 years ago and 200 years ago. It's a continuing set of issues. But I think your question goes to the absolute heart of what this is really about.
Okay, thanks very much, Philippe, and thank you all for coming. That was great.
Thank you very much. If I can just ask you to all stay in your seat just for one more moment. My name is Colin Lauder. I'm chairman of the Whitehall Group, and it was a great pleasure to have you all here today. I want to welcome my colleague as well, Ian Marcus, who's president of the University Land Society. As is customary, there's a couple of thanks, particularly, obviously, Professor Sands for a fantastic and enlightening discussion. For the panel as well, thank you all for joining us. Thank you for your time, energy, enthusiasm, and to Gideon as well for so ably chairing. I want to also thank as well our hosts, Carter Jonas, Fiona Jones in the Society, Shock Productions, and our sponsors who have made this all come together so well and so professionally. But as many of you have noticed, on the documentation, on the literature, and the brochures, this Whitehall Lecture Series hits a particular milestone this year. It's the 10th annual lecture. It's a lecture series which has covered an incredibly diverse range of topics. Many of you will know, and Ian I'm sure will tell you, that the Land Society obviously has its origins in property, in land economy, in surveying, but many of us, those of us in the industry, get quite bored about hearing those topics too frequently. So it's great to have a much more broad sense of how we think and how we evolve. But also, this is the 10th annual lecture organised by someone who I hold in very, very high esteem in this organisation. That's Douglas Blawston. Douglas got me involved in this and took me under his wing when I had just finished up and come down from Cambridge, and he had set up this new organisation, the Whitehall Group, in 2014, a group which now I'm honoured to be chairman of. But he also invigorated and drove the University Land Society to new heights during his presidency, and the organisation wouldn't be what it is today without his efforts, his energy. And I'm sad to say also, he tells me this will be his last lecture series. Douglas, you've been an inspiration to us in this organisation. You've been an inspiration to those of us who listen in, who learn from these topics. We are better thinkers, better doers, and have a better understanding of the world because of what you've brought to the university and to the organisation. Thank you very much for your efforts. Thank you for a superb lecture series and a fantastic 10th lecture. Douglas, thank you.
Ian, thank you. As they say, I couldn't have put it better myself. I have the honour of being president of this organisation, which, as Douglas said earlier, is the oldest alumni organisation in Cambridge with just over 1,000 members. But it's fair to say, just to reiterate what Colm has said, that its relevance and impact was really regenerated under the leadership of Douglas's presidency of the Society. He gave it real momentum and really reinvented it. And Cole's wouldn't be what it is today without his much broader contribution. As he says, he claims it's his 10th and last Whitehall lecture. I'm hoping beyond belief that, like Frank Sinatra, his retirement will be followed by many comebacks. And that's my job to browbeat him into staying involved as much as we can. Tomorrow evening, I go up to Cambridge and actually co-host a careers fair for the young students. And as Colm has said, we have to tell them that the world of real estate and the built environment is much more than just bricks and mortar. The top of everyone's agenda today is ESG, whether it's the E, the S or the G, depends on the organisation. But yeah, that's what we've really talked about today. You can talk about this in whatever form, but it's partly about governance and responsibility. And we'll be emphasising those things tomorrow, as well as diversity and inclusivity, something that our industry still has a lot to learn about. We are there to support the departments of land economy and architecture, both the students and the staff. We are there to bring together as a network both the existing students and the past students of different vintages. And I feel it's our responsibility to engage and promote and communicate debates like today. As someone who got to the esteemed level as O-level history, I've learned so much today. So thank you to Philippe, Thank you to our esteemed panel for your contributions that you have made today. And above all, just to reiterate, Douglas, thank you for everything you've done in putting together tonight and for everything you've done for both the Whitehall Group and Cambridge University Land Society. We're very grateful indeed. Thank you, everyone, for joining us. Very much appreciated. Thank you.